Good morning, everyone. Thank you for signing in and listening on this lovely Thursday morning. I am Gemma Chubb. I'm a senior associate here at Field Fisher in Silicon Valley. I'm actually an English qualified employment lawyer. Apologies for those of you who already know me and who have already listened to me before. As well as English employment law, I practice in data privacy. So on a day-to-day basis, I advise employers from here on the West Coast on contentious and non-contentious European employment matters. I also advise on workplace privacy and handling data subject rights. This is the second webinar we've done on discrete points arising under the GDPR. Some of you may have listened to our first session on access requests about a month ago. Today, we'd like to speak to you about the right of erasure. Now, there's been quite a lot of clamour about the right to be forgotten. And whilst the right isn't as established as the right of access, it did exist before the GDPR, just since the 13th of May 2014, to be precise, when the European Court of Justice in the Google Spain case decided that European citizens have the right to ask search engines to remove irrelevant links and outdated data. Article 17 of the GDPR builds on that right. It says that a data subject has the right to have their personal data erased by a controller. I'm going to look very briefly at the right itself. It's triggered where a data controller no longer needs to process the data subject has withdrawn consent, and I'm paraphrasing here. The data subject has objected to processing. The processing is unlawful, or the data controller is required to erase the data by law. Then we have the exemptions to the obligation to act on the request, and they are where the processing is necessary for the exercise of a right of freedom of expression or information. So we're thinking there of journalists and newspapers. Where the processing is necessary for compliance with legal obligation that requires processing by law. Say, for example, in the employment context, in Europe, there's an obligation for employers to keep working records. Where the processing is necessary for the public interest in the area of public health, or where the processing is necessary for the establishment, exercise, or defense of legal claims. So again, in the employment context, we'll be thinking of the situation where an employee is bringing a claim against the employer. It wouldn't be necessary for that employer to erase their data if they asked them to. I've always thought that when you look at the actual text, it doesn't seem that complicated. And certainly, again, in the employment context, and forgive me for always pegging my examples to employment, where an employer relies on grounds other than consent to process employee data, and they carry out thorough privacy impact assessments, then data subjects are less likely to be able to trigger the right of erasure, as the conditions won't be met. However, the application of the right is not as straightforward as it may initially seem. And since the 25th of May, we've received tons of questions which highlight this point. What we wanted to do, therefore, is to use the next 40 minutes or so to share some common questions and issues with you, and hopefully shed some light on how to handle these sort of questions. Now, I'm joined by two of my most excellent colleagues who are also based here in Silicon Valley. And full disclosure, we're actually sitting in one of their kitchens at the moment around the kitchen table. So we've got Felicity Fisher, also known as Flick, who's a legal director. She specialises in privacy and digital regulation. Flick, like me, is an English qualified lawyer, and she's been based in the San Francisco Bay Area for 4.5 years. And we've also got Anna, who's an associate specialised in European and international privacy, and is a French lawyer and also registered with the California Bar. She's lived here with her family for 5 years now. What we've done is dug out some of the trickier questions that we've been receiving over the last few months. In doing so, we garnered input from our team here in Silicon Valley, but also from our privacy colleagues from across Europe for the most interesting questions that they've received. What we're going to do is go through some of those questions with you and share our thought processes. And whilst there is no one case fits all answer to most of these questions, what we hope you'll get is an idea of where to start if you receive the same or similar questions. If you have any questions throughout the session, please type them in and send them over to us. You're all on mute. Even if we don't have time to answer all of the questions received, what we're going to do is collate them, and we'd like to circulate written answers to them after this session. We'll circulate them with a copy of these slides and a recording of the session in case that will be helpful. So without further ado, I'll hand over to Flick for our first question, which is, does the data really have to be deleted, or can it just be put out of use?
Yeah, no, thank you very much, Emma. So I have to say the issue of whether or not data should be deleted and how to delete it is the thing that is causing my clients some of the most GDPR-related compliance anxiety. And that's probably because in most data processing ecosystems, the reality is that there seldom exists just a kind of single copy of our data. For most people or most companies, data is distributed, backed up and archived across multiple systems, drives and tapes, and often across different geographic locations. And actually, far from that being a bad thing, data distribution, archival and backup is actually better because it preserves the availability and integrity of those records, which actually is something that the GDPR sort of encourages people to do as part of demonstrating they've put in place appropriate security measures. But the sort of quid pro quo of that greater data reliance is that commitments to kind of comprehensively wipe every last trace of our data become really difficult to comply with and in some cases unachievable. And just to add kind of more complexity to this is that we know the GDPR says we mustn't keep data for longer than is necessary for the purposes for which it was collected. And we also know that we could be required to erase data. But because we're dealing with a principled piece of legislation, the GDPR doesn't define what deletion is or what erasure is. So we're kind of forced to look to available regulatory guidance and kind of plain English interpretations of all of this. And at the moment, we don't have any guidance that's kind of, well, not much guidance that's been prepared under the GDPR regime. So we're kind of looking back to old guidance to kind of currently interpret how we should comply with all of these obligations. So if you looked at a kind of, if you took a plain English interpretation of what it means to delete or erase data, we're probably talking about, and the regulators would probably want you to permanently destroy or dispose of that data. And that would be a permanent deletion or disposal across all of your systems. So that would be live systems and backup systems. So on that sort of interpretation, just archiving data in a kind of structured, retrievable manner wouldn't constitute deletion and would still be subject to the GDPR. But then we sort of have to look at what some of the guidance has said here. And actually, the UK regulators have come up, or have historically come up, with some pretty pragmatic guidance that can sort of help companies here. But again, this is guidance that was issued under the old directive and back in 2012. So we'll wait to see whether or not any new guidance that comes out kind of offers the same help. But the UK regulators previously kind of recognised the difficulties in trying to delete certainly electronic data. And so they kind of arrived at a slightly more sensible solution than complete permanent destruction. And they kind of indicated that data could be deleted for if data couldn't be deleted for technical or other reasons, then it would instead, it could be put beyond use. And so they kind of said that there were 4 components to putting data beyond use. Basically, you need to ensure that an organisation will not and cannot use the personal data to inform any decision in respect of any individual, or in a manner that affects the underlying individuals in any way. So you can't use it to do any profiling or any processing that could impact the individual. You've also got to have strict access control, so it's not to be shared with anybody outside the organisation. And you've also got an ongoing obligation to continue to protect the personal data with appropriate security measures. And then you can't just sort of say you put it beyond use and then ignore it. You've got to commit at some point to delete the data if and when it becomes possible. So there's got to be a plan in place to at some point delete it. So it's basically giving you a kind of practical way to say, well, if we can't instantly completely delete it, then provided we put it beyond use and we can show that, you know, technically it was pretty difficult to achieve immediate deletion, then it may be possible to argue that putting it beyond use is the kind of sensible way of sort of addressing that deletion obligation until we can more permanently delete it, i.e. overwrite it at some point in the future. Now, that is the UK regulators' view, and actually I was looking on their website for any kind of updated guidance, and they have provided on their website, and this is more recent guidance, and they also say that if an erasure request or a deletion request from an individual can't be instantly fulfilled in respect of live systems, but that the data will remain within the backup environment for a certain period of time until it's overwritten. Again, that may be okay. You can put it beyond use, provided that you kind of meet those 4 conditions. So again, there's some recognition in the recent guidance from the UK regulators that it might be okay to put it beyond use in certain circumstances. But again, other regimes, you know, Germany probably being one, are likely to require more kind of permanent actual deletion unless there's no or kind of negligible risk of the files being recovered. So I think if we have to give you a kind of sensible general rule of thumb, it would be delete if you can, and if you can't, make sure it's stored securely and don't let anyone else use it.
Thank you, Flick. So another question that we get quite often is, can I keep the data as long as I anonymize it, or can I just hash it? So under the GDPR, anonymization is not, anonymized data is not regarded as personal data. That means that truly anonymized data amounts deletion. So you don't, if you can truly anonymize the data that you have about an individual, then that's sufficient. You will have complied with the obligation to delete that data. The issue here is that the Working Party 29, which is the European regulators' guidance, has a very strict definition of anonymization. The standard is really high. The data that is anonymized is regarded as anonymized when we are not capable of singling any specific individual out. We cannot link that data to another data that will allow us to identify an individual. And that data cannot be used to deduce an individual's identity. So that's quite a very high standard to meet. And in practice, we haven't seen a lot of clients being able to meet that standard. The UK ICO, so the UK regulator, has a more practical approach, which is the motivated intruder test. So under that test, we look at a person who starts with no knowledge, no prior knowledge, but who wishes to identify the individual from whose personal data, the anonymized data, has been derived. So this intruder is reasonably competent, has access to many resources such as the internet, library, public documents, and would employ investigative additional knowledge of the identity of the data subject. So we'll be able to ask other people, advertise, so that people will come forward with any information that they will have. But that individual has no special skills or knowledge. So a good way to determine whether that data could be linked back to an individual is looking at social network, public search, public archives, and just making sure that there is no way we can link that data back to an individual. So that's anonymization. Hashing, on the other hand, is regarded as a pseudonymization technique, which means that we replace for instance, the name of that individual or any identifiers with a number. That's not sufficient, just because we can still link back to that individual using all the means that are likely to be used, or any reasonable means. So that's still regarded as personal data under the GDPR, just because pseudonymized data is regarded as personal data. So that falls within the scope of Article 17 and should be deleted.
Yeah, and I would just add to that. So, you know, if you looked at the Article 29 Working Party guidance on anonymisation techniques, you know, it's very clear that the regulators just don't believe anonymisation is possible. So if you looked at that really strict interpretation, we would, you know, your heart would sink and think we can never anonymise data to that standard. And I would just say that that guidance is obviously not legally binding. And I think that it's more about, you know, if you can show that there is a really kind of negligible risk of the data being re-identified so that you could actually single out an individual. I think if you kind of, you know, tested the data set and are reasonably certain that it would be really very difficult to re-identify the individual using data, you know, both within your systems or that could be easily sourced from a third party or in combination with data from a, you know, a quick public search, then I think you've got a reasonably defensible position that the data has been anonymized. But I would say a lot of these questions are ones for data scientists and not lawyers. You really need to get those folks involved in testing the data sets to see whether or not you could stand behind a kind of commitment that the data has really been anonymized.
It does make it interesting, therefore, doesn't it, that the ICO has adopted almost like an innocent bystander kind of average Joe blogs type test to anonymization, when actually the working party, the Article 29 working party guidance sets the bar so high, they don't quite seem to sit together neatly enough.
The ICO's approach is much more practical, which is what can happen in reality, in practice. They are not, for instance, when they mention the motivated intruder test, they exclude a hacker. So it means that you should not take the position of a hacker trying to re-identify the individual, but really just a random individual with normal skills and normal knowledge.
Yeah.
So next question, again for Flick, is encryption and throwing away the key enough for deletion?
Yeah, so very interesting question. So, and again, I'm not a technical person, but my understanding of encryption is that it alters the data by using a specific secret key. This is my layman attempt to describe encryption, which is defined in an algorithm, which basically renders the resulting data set unreadable. And the only way to kind of return it to a readable format is to rely on a corresponding key to effectively unlock the data. And so there are a couple of issues to consider. So first of all, I think it's worth considering just encryption alone, you know, satisfying deletion requirements and erasure requirements. And then, you know, the second part, if we threw away the key, does that impact our analysis? And again, if we were to kind of look to the really conservative Article 29, over the, you know, previous coalition of kind of regulators who came up with opinions on data protection law, if we looked at their sort of opinion, they regard just straightforward encryption as a pseudonymization technique. So again, pseudonymized data, as Anna was kind of neatly saying, is still regarded as personal data. So if we, you know, and given the sort of high threshold for anonymization, I think straightforward encryption, we would have quite an uphill struggle arguing that that was enough to delete the data, given that the key is still in the hands of somebody, and so there's a theoretical possibility that somebody could, you know, unlock the data at some point. But I do think that there is more scope to argue that the data has effectively been fully anonymized if you were to completely destroy the key. And again, we need to think through and kind of test that data set and remember that the definition of personal data is extremely wide. So it talks about data that, you know, relates directly or indirectly to an individual. And we look at the recitals in the GDPR, and it says that all means reasonably likely to be used either by a controller or another person should be factored into deciding whether or not that information is identifiable. So I think to demonstrate that encryption and key destruction, you know, satisfies the kind of test here, I think you need to really, it will depend on kind of the extent to which the data has been masked, the available technology that could be used to crack that encryption. And, you know, again, a question for the data scientists and the more technical teams to really be able to demonstrate that the destruction method was, you know, sufficiently robust and irreversible to kind of defend you know, an argument that encryption and throwing away the deletion key is enough to say that the data has been deleted. And I should also say that if you're kind of relying on anonymization to, or you know, encryption and throwing away the deletion key to satisfy your deletion or erasure obligations, there's an ongoing commitment to make sure that you keep testing that that remains anonymized. So, you know, you always have to factor in available technology, and if things change and suddenly actually it'd be easy for someone to hack that data and get to and re-identify it in a readable format, then you haven't met the test. And similarly, you know, is it enough to satisfy the individual's right to erasure? If we looked at the kind of UK more practical guidance, which allows for kind of data being put beyond use to satisfy an erasure request, then we may be able to argue that, you know, encryption, or indeed encryption and throwing away the deletion key, may be enough to satisfy the erasure requests. But you've always got to, you know, the guidance is very clear that you've got to tell people what happens to their personal data once it's been deleted. You know, if you've put it beyond use, then that's something we may need to articulate to the individual when we're responding to the request.
Another question is, do backups need to be deleted? So there is no exception in the GDPR for data that is stored in backups. We see some exception in other regulators, in regulators' interpretation and guidance, but nothing under the GDPR. So again, a more practical approach that we, the ICO guidance as released in 2018, and I think the CNIL has a similar approach, is fine. It's fine if you put the backups beyond use. If you cannot delete a certain individual's data within the backups, then you just want to make sure that you put them beyond use and they are overwritten. So in any case, if you cannot delete a certain individual's data within your backup, you need to mitigate the risk. To do so, you need to make sure that the data is stored in pseudonymized or encrypted form when it's possible. So hashed data or encrypted data. You need to ensure that it is securely stored. You need to isolate the data and restrict it from any further processing. So you just want to make sure that it's the only reason why it's kept is because you cannot technically delete it and you need to keep backup. But if you you should keep a record of any deletion request that you received, just in case if the data is restored accidentally, you need to make sure that you will be able to delete that data related to the individual making the request. And of course, you need to be able to delete the data as soon as it is technically feasible. So you should have a plan for deletion. So I think what's interesting here is that you should take what a regulator's approach will be if you were to tell them that you've kept some data in backup. So if you can justify that, if you can explain that technically, if you delete that individual's data, you're going to have to delete all the backups, and that because you are required under the GDPR and many privacy laws to keep trace of the data so that it remains accessible and you can restore that data, then you need to keep that backups. I think that's completely understandable, but again, you should be transparent about it. So you need to be transparent if you receive a request from an individual, and if you cannot delete that data, you need to keep it in backup, and you need to make sure that it is actually just used in backup and not accessed by your marketing team or any other team.
Yeah, and I think the important thing as well is if you're going to keep it in backup, ensure that that's you know, that backup is kept separate from the general restore files, and that it's internally marked. You know, so if accidentally the data is restored, then there's a marker on the data showing that it was actually not data that should be used within the live system. The other point I would just raise here is that you know, as a controller, you have the ability to kind of determine your deletion strategy. So you've decided that you've got a reasonably defensible argument that, you know, the data is, some data needs to be kept in backups due to the technical difficulties of deleting all of it. And, you know, you can kind of build a good story, and, you know, demonstrating some of these steps that Anna's just described really help you build that story. It's a slightly different position when you're a processor, because, and we're going to talk about this a little bit later on, so I may be jumping the gun here a bit, but I'm just going to set, you know, just remind people that if you are acting as a processor, your obligation is to only, you know, is to act on the instructions of your customer, the controller, And you basically have to delete the data when they request request that it be deleted. And certainly the GDPR requires it at the end of the contract. There would be a legal obligation to delete the data. Now, if you need to retain if you can't delete all of the customer's data and you need to retain it in backups, then unless you kind of contractually carve out that, and make it clear to the customer that that's going to happen, maintaining that data in backups and not deleting it could put you in breach with your contractual obligations as a processor to act on the instructions of the controller and to delete it at their request. And we're going to talk a little bit more about that later, but it's just something to be aware of, that you might contractually need to deal with that if you are a processor, to make sure that you're not overstepping your processor role there and exposing yourself to contractual liability.
Next question. I'm trying to set my retention periods and what's a sensible approach. So this is a slight tangent to erasure, but relevant nonetheless. Again, as the GDPR is policy-based, it doesn't set strict retention periods for personal data. It merely says, and Flick's already said this, when you're acting as a controller, personal data should not be kept for longer than is necessary for the particular purpose it was being retained. It also says that it should not be kept in a form which permits identification of data subjects for longer than is necessary. In other words, and as we've already said, when we talk about deletion after a period of retention, we do mean deletion or true anonymization. Both are options. So the brief answer to this question, and or the first thing to say that is, if you have a legal obligation to retain the data, then you can retain that data for the duration of that legal obligation. For instance, if you have to retain records for tax and accounting purposes for 6 years, then to keep the data for 6 years. But applying that is tricky. You'll be under legal obligations to keep data for various reasons, like, as I said, tax, corporate law, accounting, insurance, compliance, employment records. So same data needed for different reasons. And the legal requirements and the statute of limitations will vary from country to country. I could be wrong, but I don't think that any one person will know all of the various statutes of limitations and laws that will apply to each data set for each reason. We might try to, but I don't think it's possible, and across every different country. What you'd have to do if you wanted to apply a completely accurate and robust retention policy, adopting that very specific approach, is to seek specialist advice in every single field. That will be time consuming and, most importantly, very, very, very expensive. So from a practical perspective, we typically advise clients that having some sort of time period is better than having none at all. If you want to take a pan-European or a global approach, and that's something that many of our clients do, and you're prepared to take some sort of calculated risk, you could set a maximum limit beyond which no data should be retained. And then you can try to approach your different business heads and say, and explore with them whether they have any need to retain data beyond that, that maximum limit. So applying that, a sensible approach might be to think about which EU territory you have the greatest presence in, and use the various statutes of limitations in each case as a starting point. Just to be practical again, like think about in the UK, employment claims have to be heard in a tribunal, and an employment tribunal, and the claims normally have to be brought within 3 months of the action in question. Now, I wouldn't recommend that any client deletes employment data within 3 months of, for instance, someone leaving. However, and the main reason for that rather is that with high court claims, people have 6 years to bring a claim. So taking that as an example, you could then say use something like 6 or 7 years as your overall pan-European approach to retaining data. You could then speak to each business function and ask them to work out whether they have any need to retain data beyond that maximum limit. And when you ask them, explain to them that you want them to provide justifications, if necessary, about why the limit is not long enough. It's not enough for them to say that they just want to keep the data for longer. They have to be able to justify their need to keep the data longer, and also show that they're taking the individual's expectation of privacy into account. So to expand on this a little further, what you're aiming to do is to get any business head who thinks that they need to retain data to show exactly why, and ideally with statistics. You want them to show that they need to demonstrate the data, and that actually that the data is need to be retained in anonymized form. That is, that the desired result could not be achieved by using aggregated or anonymized data. I'm thinking of one particular instance with a particular client who had pushback from one of their departments, where they wanted to keep data for much more extended periods of time. We asked them to provide some sort of statistical evidence about why the data needed to be retained. In that particular case, the business unit was saying that they needed to retain customer data for 10 years after account closure, on the basis that many customers returned within that period. Fine. But actually, when we looked at the statistics, the great majority of the customers who did returned within the first 3 to 4 years. So after that, the return rate dropped off significantly. That fact alone and those statistics helped compliance within that particular client to argue that the shorter retention period would, after all, suffice. Moving on to the next question. How do we reconcile the obligation to delete personal data with retention obligations? So I've touched on this already, and it takes us back to one of the exemptions to the right of erasure. Article 17.3 says that the right of erasure won't apply if the processing is necessary for compliance with a legal obligation which requires processing by union or member state law to which the controller is subject. So the short answer is, if you can point to a clear legal obligation to retain the data, then you don't need to erase it. But remember that you need to think about the legal obligation being relevant in the jurisdiction in which the erasure request was made. For instance, and Anna, correct me if I'm wrong, in France, their payroll and salary records need to be kept for 7 years. That would include information about employee names, dates of birth, tax registration, and more. There is no similar requirement to retain such information in the UK. So even if you've adopted a pan-European approach and said, okay, we're going to retain all of that employee data for 7 years, and you have an employee in the UK for asking for erasure within that period, or an ex-employee asking for erasure within that period of time, the fact that you have a requirement to retain the information in France will not be sufficient to trump the right of erasure. Another point to consider is the capacity in which you hold the information. As Flick was saying earlier, what if you're a data processor rather than a controller? A processor can only act on the instructions of the controller. So in theory, this means that they should delete customer data at the request of a customer. However, some processors will want to carve out certain rights to retain data, for instance, for their backups, because they can't easily delete data quickly, or to comply with their own legal obligations, or to defend against legal claims, etc. If a customer later decides to bring a claim, they need to be able to defend themselves. In the most cases, pure customer data in that scenario won't be relevant, but there may be certain logs and support files that are important to retain. It's tricky, isn't it, Flip? Because most processors will almost always be a controller of certain customer data for, say, CRM, billing purposes, and in relation to other retention for audit or defense of claim purposes. But in your experience, do agreements actually deal with this?
Yeah, it's a really tricky one. So as a general, contracting strategy, we all know that most service providers who claim to be acting as a process, and sorry, the garbage truck has decided to arrive at a crucial point in the webinar, so apologies for the background noise. Yeah, so we all know that anybody who says that they are absolutely a pure processor of any data they process in connection with the provision of a service to a customer is gonna, that's a very difficult position to defend, because any service provider will be collecting and retaining data for account management, for client relationship purposes. They may also, particularly for SaaS services, be scraping a whole load of usage and performance data around how individuals are interacting with the service so they can make product improvements. There may also be support log data that they're collecting, and they sort of spot support issues across their customer base. So there's going to be a whole load of data which actually, if they were being honest about it, they're going to be a controller of. But we all know that, trying to negotiate, controller to controller terms within generally a processor deal is an uphill struggle. So lots of people kind of tactfully sort of say, well, we're just not going to deal with the controller aspects, and we're going to rely on things like, well, the contract only covers personal data to the extent we are a processor, so we'll just rely on that to be kind of silent about our controller use cases. The problem is that there's sometimes overlap between the data for which we're a processor and the data for which we're a controller. So we've now committed to delete the data from our systems, but actually we need to retain it for the reasons Gemma said. So that you can kind of, without having to fully, deal with the controller to controller aspects, you can sort of try and navigate it by effectively getting instructions to retain the data for those use cases. It's not perfect. We know you're still a controller, in fact, but at least those use cases don't end up causing you to, breach the customer agreement, because now you've got clear instructions from the customer, enabling you to keep it for those purposes. But it's a bit of that's a potential deal friction point, because you end up having to commit to, keep it isolated from further use, effectively put it beyond use. In the case of backup, certainly.
So 2 hopefully quick questions on that, Flick, is firstly, how would that play out, do you think, in a scenario if the processor is having a legal dispute with the controller? Would they then have to say, oh, by the way, we need to retain some of this data because you're suing us? And I guess my other question relates to the notice provisions to the data subjects. Do you think that processors are doing enough in their privacy notices to explain to average Joe blogs that they may be retaining some data as a controller?
Oh, where's that garbage truck when you need a hard question at the end? So I think that certainly everybody that was kind of diligently going through their GDPR processes and who had historically just been a processor took a deeper dive into their processing activities, and so they've become far more aware of certain data processing for which they're a controller, and certainly lots of my clients who kind of acknowledge certain controller aspects of their service provision started to do things like create end user facing notices on their websites and to trying to deal with some of those transparency issues. But it's a sort of an issue where people take I'd say a lot of people take a bit of a risk on addressing those controller aspects of their general service provision. I don't see many people getting that piece perfectly right.
So next question is, if I action an erasure request, what record should I keep that the data has been erased, if any? And if I keep a record, how long should I keep it for? So under the GDPR, there is no requirement to keep a record of the request and the action that you've been taking upon such requests. But because you need to demonstrate that you are compliant, you need to demonstrate your compliance with the GDPR and with the request that you receive, we advise our clients to keep records of any deletion request or any access request or any request from a data subject. You should keep a record of when the request was received, what communication you had. So did you respond immediately? What did you do? When did you act? And when the data was deleted. And you also need to keep records of any opt-out or unsubscribe requests that you've been receiving. So any request to stop marketing communication, you need to keep that record. So what happened most of the time is that you have an individual that is asking you to delete all the information that you have about them, but you realize that you have them in your unsubscribe list. So in that case, we have many clients asking us what they should do. Should they keep the name in the unsubscribe list, or should they delete the name? So I think here, if you take a reasonable approach, you should simply keep the name in the unsubscribe list. You may want to let the individual know that you're keeping some of their data within your record, just to ensure that you're not going to send them any marketing communication in accordance with their preferences. So how long should you keep these records? I think that in practice, you should not need to keep these records for longer than the applicable statutory limitation period. So as Gemma explained, I think because these statutory limitation periods are different in each country, it will really depend on your retention period decision. So how do you want to approach that? Do you want to do country by country or globally in Europe? So there is no clear specific answers here, but I don't think that you should keep it for longer than the applicable statutory limitation period. And of course, another thing to remember, if you keep records of deletion requests that you receive, you want to make sure that these records are isolated. So they cannot be accessed by anyone. They cannot be used for any other purpose than demonstrating compliance with the request.
Cool. So I think the final question we're going to tackle, we've got 4 minutes left, I think. So what do you have to do if you're a processor and the controller gets a deletion request? Yeah, so what are the scope of your obligations as a processor? So so as you know, we kind of briefly touched upon, as a processor, you're required to comply with your controllers, your customers in most cases, processing instructions. And the GDPR also introduced a whole kind of bucket list of terms that now have to be introduced into the contract. And one of those is that a processor is now kind of required to commit to assist the controller by appropriate technical and organizational measures, insofar as this is possible, for the fulfillment of the controller's obligation to respond to requests. And my take on this is that sort of requiring the processor to think about whether or not it needs to factor in any engineering changes or solutions to its product to make sure that it can easily help controllers comply with their requests to delete data, provide access to the data. And so there is the caveat that this is insofar as is possible. So it's not an absolute obligation to do this. You've got to basically try your best to try and ensure that your product and service enables the controller to, or helps the controller to comply with their obligations to the data subject. As a processor, you don't have a direct obligation to the data subject. It is a purely kind of contractual obligation that is driven by this Article 28 requirement. And so what a lot of people doing, if you're, for example, a pure hosting service, and then often what you'll do is you'll say, look, you guys, customer, are in absolute control and have full access to the data that you are inputting into the service. And so through the portal or whatever interface the customer has to their data, you are able to directly access, to delete the data, to correct the data. So control is in your hands. We've made it possible for you to do that. And we've kind of met our obligations by providing you with that ability to directly address the issue. And then, and again, this typically is a sort of pure hosting example. If the customer needs additional support because perhaps they need to do a deeper dive than they're able to do through the interface, then often that extra support is something that is commercially scoped out and agreed. So you may say, look, we've given you the basic provision there. If you need extra support, then we reserve the right to charge for that support. And there is nothing in the GDPR that prevents you from charging additional kind of fees for helping your customers deal with some of these requests, particularly if it's going to involve, an extreme amount of engineering time and support on your side. But I think the basic premise is that you should have some basic functionality in there to help customers comply with these requests. And again, you need to really look at what the contract says, because I see a lot of negotiation around the scope of how much a processor should have to help controllers here, and it ends up being a kind of, the nuances and the details of that support are often a matter that's addressed and commercially scoped out. So have a look at what your contract says and make sure that you can comply with those commitments to help. And I would say, if you are a processor, make sure you think about this from a, you know, an engineering standpoint, from a cost standpoint. You may not have factored in having to provide this kind of support into your standard licensing fees, but you know, we are starting to see data subject requests that they certainly are increasing, and have, you know, in post GDPR there was an enormous rush of these requests, and it was very time consuming for people to comply with it. So these are sort of aspects that you need to think about moving forward, and factor into you know, how you're pricing your service and the functionality that's offered within the service.
Thanks, Vic. So that brings us to the end of this session. We have received a few questions, and because we're trying really hard to make sure we stick to our 45-minute slot this time, unlike last time. So what I'll do is make sure that we circulate answers to the questions that we've received from you during this session in the next couple of days. With those answers, we're going to circulate a copy of these slides and the recording. We plan to do another session next month, and I'll email you with details of that at the same time. If you've got any strong preferences about topics that you're finding particularly tricky, then please do let us know. We're really aiming to make this as current and practical and useful as possible. And thank you all very much. Have a wonderful Thursday. Thanks. Well done for getting to Thursday. Looking forward to Friday, and have a great rest of the week.
Yeah, thank you very much.